That brings us to William Fuller against Okaloosa Correctional Institution and the Division of Risk Management.
May it please the Court. My name is Bill McCabe. I represent the claimant William Fuller. In this case, the Judge of Compensation Claims found the employer carrier presented competent evidence to rebut the presumption of compensability afforded a claimant by the provisions of Florida Statute 112.18 parentheses 1. And as such, the judge found claimant's heart disease was not compensable. We submit there's no competent substantial evidence to support this finding. By the way, I'll reserve 2 minutes for rebuttal. Forgot to say that. In this case, the judge found claimant was entitled to the presumption of compensability afforded the claimant by the provisions of the statute 112.181 for his December 5th, 2007 accident and subsequent heart condition, which the judge seemed to accept was right ventricular outflow tract tachycardia, RVOT tachycardia. In reaching this conclusion, the judge found claimant was a corrections officer. He successfully passed a pre-employment physical, which revealed no evidence of heart disease.
What year was that, counsel?
I beg your pardon?
What year was that he passed the exam?
He passed the pre-employment physical in 1996.
After the 95 incident?
After the 95 incident, yes. Anyway, he has heart disease now, and he was disabled. So in order for the...
Is it clear this is heart disease? I mean, wasn't he chewing his tongue?
The judge reached the conclusion that the claimant suffers from heart disease. There was a dispute between the physicians as to the diagnosis. Actually, after the 2003 incident, Dr. Mathias seemed to think he had sick sinus syndrome. Dr. Vadu seemed to think he had vasovagal syncope. But then after this 2007 incident, which is the incident on appeal in this case, Dr. Mathias thought he had RVOT tachycardia because he had a real high heart rate, whereas previously it appeared that he had a low heart rate. And so he must have had RVOT tachycardia, or else he couldn't have had a high heart rate.
Now, your doctor, I believe, was it your doctor that said he did not have RVOT, or was that the employer's doctor?
That was the employer's doctor, didn't think he had it. Right. The employer's doctor still seemed to think that he had the vasovagal syncope.
And that was, there was testimony that that's what occurred in 1995, right?
Well, okay, that's where my argument is. Now, this is the December 5th, 2007 incident. The March 28, 2003 incident was already on appeal before this court. We had oral argument July 30th in Tampa. You were on that panel. And this honorable court affirmed the judge's decision in that case with a PCA opinion. But here we're on the 2007 incident. There are some differences between the two incidences.
The pacemaker being the key difference, right?
Well, the pacemaker was installed after the 2003, and that is one of the ways they could establish that he had a real high heart rate in the 2007 incident. But also the 95 incident and the 2003 incident both occurred, the man passed out, had a syncope episode, while he was outside in hot weather mowing the yard. This December 5th, 2007 incident, while also a syncope incident, occurred while he was shopping at Walmart early in the morning. And he hadn't eaten breakfast. He was going to get some breakfast when he passed out. But my argument, the judge found that the presumption was rebutted because the judge found the 95 and the 2003 incidents were nearly identical in circumstance and character. He found the 2007 incident was not nearly identical in circumstance or character, but was nevertheless a syncope episode. So the judge concluded that whatever caused the incidences in 2003 and 2007 was the same thing that caused the incident in 95.
Now, let's say that he's entitled to reach those conclusions. It remains the case that your man passed the pre-employment physical.
Correct. And
that's what the statute says triggers the presumption.
correct. And not only did he pass the pre-employment physical, but there is absolutely no evidence in this record prior to him becoming employed with the employer herein that he had heart disease. None. There's not one word in this record that shows he had heart disease prior to becoming employed with the employer herein. After the 95 incident,
Well, what was the 1995 incident then?
he was saying he was mowing. This is before he got hired.
Right, but isn't that a heart incident?
No, there's no evidence it was a heart incident. There's not a single medical record in here. Now, what happened after that incident is he went to Crestview Hospital. Apparently, the Crestview Hospital medical records were not placed in evidence. And apparently, from what I understand from counsel for the employer carrier and from counsel for claimant, is they actually weren't located. But you do have Dr. Payne's records. Dr. Payne saw the claimant about 2 weeks after the incident. There's no indication in there that the claimant had heart disease. Dr. Payne saw him again in 1996, no incident of heart disease. Dr. Payne did a physical for him, not only the pre-employment physical, but he did another physical in 96, I guess before he was going to correctional school. No evidence of heart disease. Then when he gets to the May 28, 2003 incident, which is after he was employed, and that was the first claim that we sought to claim to be compensable, when he's in the hospital, one doctor who sees him in there, Dr. John Johnson, says the patient had a similar episode while cutting his grass in 1994. He had a negative cardiac and neurologic workup at that time. Dr. Shallett, who saw claimant after the May 28, 2003 incident, stated under past medical history, similar episode of confusion and near syncope in 1995. The workup was negative. Their IME testified that the August 14, 95 incident was non-cardiac in origin. There's also medical reports in here.
So your argument is essentially the 95 incident is non-cardiac. That's
Correct.
what we relied on by implication, although we didn't write an opinion, to find that the 03 incident was identical to the 95 incident. You're essentially now conceding, fine, the 03 incident's identical. I lost that case. But in 07, I have a different incident that can't be linked to the 95 incident.
Well,
I don't mean to make your argument for you, but I mean, is
Well,
that not the heart of the matter from your perspective?
it's partly the argument, but the argument also...
Doesn't one of the doctors say all three are probably caused by the same mechanism?
There's their doctor, and this deposition was taken after the 2003 case. Their doctor does say on page 450, this is probably maybe their best point. Page 450, he says, the question is, whatever the diagnosis is for the 2007 episode, do you think that this condition could be related to the episodes he had in 1995 and 2003? Answer, I do. Question, do you think it's more likely than not that all three of these episodes are related? Answer, I do. That's their doctor in his December 08 deposition. So that might be their strongest point. But the argument that I'm trying to make is, and in addition to the medical records I already referenced, Dr. Payne, who was his general practitioner, his medical records are in here all the way from actually 95 through May 13th, 03, which is before the May 28 incident. There's not one reference to a heart condition in any of those records either. Not one.
I'm sorry, could you repeat that? What you just said?
Dr. Payne, who is the claimant's family practitioner, not only did he have the records that I already discussed, but he continued to treat the claimant for other things like bronchitis and sinusitis and all that stuff. And his records they're on page 271 through 296 of the record. From April 24th, 97 through May 13th, 03, I stopped there because May 28, 03 had that incident while at work. But none of those records reference that the man had any heart condition either. So the point I'm trying to make is Yeah, it might sound good that since he had 3 syncope episodes, they're all related to the same thing, and the doctors would like to have one common diagnosis if they could. I don't see how you can establish that the heart condition that he clearly has now was the same heart condition he had in 1995, or before he was employed, when the medical records back then show no evidence that he had any heart disease. None at all.
And you don't think the evidence that you candidly acknowledge, although your opposing counsel may say she has other good points, that's not sufficient, competent, substantial evidence in your view?
It's not because of the fact that there is other evidence going back before he was hired that shows no evidence of heart disease at all.
But his opinion doesn't meet the CSC test in your view, or the Punske standard?
I would say no, because, and secondly, too, you know, it's kind of interesting when you ask that, too, but their doctor really wasn't in agreement with the RVOT tachycardia diagnosis. He still seemed to think that it was the vasovagal syncope.
Which the JCC rejected.
The JCC rejected because of the high heart rate. Another interesting twist in their IME's opinion also is the judge found in both orders, no matter what the diagnosis was, whether it was sick sinus syndrome, vasovagal, or situational syncope, as Dr. Vadu said, or the RVOT tachycardia, it was a heart disease. That's what the judge found, and no one's challenged it. Dr. Mathias did testify to that. But interestingly, their IME, if I recall his testimony, didn't seem to think the vasovagal syncope really was heart disease, and that's kind of what he thought the claimant had. So maybe in his mind, maybe it all was related, not heart disease, but the findings of the judge are it was heart disease. The evidence in the record shows not one word that this man had heart disease prior to becoming employed with the employer. So that's our argument. I'll save the rest.
How'd you lose last time?
Hey, pardon me? I don't know. The PCA opinion, I don't know. Thank you.
May it please the Court, my name is Colleen Cleary Ortiz, and I'm here on behalf of the Okaloosa County Correctional Institution in the State of Florida Division of Risk Management. Mr. McCabe states that not one word of evidence was in the record that the claimant had heart disease in 1995. That's not exactly how we see it. How we see it is there is testimony, and perhaps our best point is the testimony of the claimant's IME physician, Dr. Mathias. Dr. Mathias said that he considered all the evidence, and he said that the RVOT tachycardia that he diagnosed, that Dr. Naidu came up with, was the probable diagnosis. He said it would explain both the 2007 and 2003. And then he kind of stops himself. He says, and it may, I'm not sure if it will explain earlier episodes. I don't know. And you have to kind of recall who, consider the source. He's a well-known claimant's IME physician who handles heart-lung cases. So he did kind of stop himself. And the interesting point is that the claimant cannot explain how the 2007 diagnosis of RVOT tachycardia, which their IME's testimony, which his opinion testimony is evidence, why that diagnosis can be applicable to the 2003 episode, but not to the nearly identical episode which occurred in 1995.
Well, I think a question that certainly arises in my mind is, the judge finds this is a presumption case. Now, in our previous case, your arguments address the 2003 incident, where the facts are obviously a little different. You don't have a pacemaker installed, you don't have the high heart rate recorded, and you don't have one expert saying that is absolutely inconsistent with vasovagal, with the other diagnoses. So and then you have the judge here saying I find it's RVOT. Well, if it's a presumption case and the diagnosis is RVOT, where is the adequate evidence to find the 95 incident is RVOT, is heart disease?
And again, I go back to a couple of things. The evidence is the expert opinion testimony of Dr. Mathias. And when you read Dr. Mathias's testimony, he discusses how they came to the conclusion that the RVOT diagnosis was applicable really to all three. He states that, and I think what I argued in the brief was that it was an elusive diagnosis. The testing...
I want to drop back and ask you this question. So, first of all, he's correct, is he not, that you are not questioning that this is cardiac in some shape or form, and that the statute applies and the presumption arises?
I think that we have not, we agree, the parties agree that the claimant meets the presumption. The parties agree that under that the sole issue is whether the presumption has been rebutted. So, and I think the parties agree with the...
What do you have to prove in order to establish, in order to rebut the presumption?
In order to rebut the presumption, under the circumstances of this case, it's the same as Punske. The standard is whether there's competent substantial evidence of sufficient weight to satisfy the trier fact that the disease had a non-industrial cause.
All right. Now, this whole presumption for the benefit of policemen and firemen, the idea is they have extra job stress.
That's correct, and we understand that and we respect that. And what I argued at the last time I was before this court was that although this is a presumption case, this is not a case where the work stressors caused or even accelerated. There's testimony about that, or there's a conclusion about that.
Well, I mean, but the claimant doesn't have to show that. I mean, the presumption assumes it's work-oriented. You come forward with competent substantial evidence, and here, unlike the case in the previous case, you have a pacemaker installed, a recorded high heart rate. The JCC saying, I find that the 2007 incident is RVOT. I find that the 2003 incident is RVOT. And it's very logical to assume and conclude that the 1995 incident is RVOT, right?
That's correct.
Okay.
But the crucial bit of evidence is it's not just the judge's finding that the 2007 is RVOT and that the 2003 is RVOT. It's the testimony of their independent medical examiner, Dr. Mathias, that the probable diagnosis for both the 2007 episode and the 2003 episode is RVOT. So if you assume...
Do you have testimony that RVOT can never be precipitated by outside stress?
Actually, the testimony of Dr. Mathias was that they have no idea what causes RVOT tachycardia.
Well, isn't that exactly where the presumption is supposed to operate? If it's just you don't know and you can't prove one way or the other, the claimant gets the benefit of the presumption.
You would think so. However, what the doctor's testimony was, and what the judge concluded was, whatever's triggering this RVOT tachycardia has occurred on at least three occasions that we know of. One in 1995, one in 2003, and one in 2007. And that, when you look at the testimony of Dr. Mathias, when he agrees and he concludes, and even at the time of the past, whether the 2003 episode was compensable, he concludes, oh yes, it must be RVOT tachycardia. So, and when you compare the 2003 episode to the 1995 episode, they're exactly the same thing. And Judge Wynn also looked at the fact that Dr. Mathias testified that we don't really know what's causing him to pass out. It could be because of a slow heart rate, which is what they kind of really thought at the beginning, which was why they installed the pacemaker. But actually, it could be caused by a high heart rate. So he really could have passed out in 1995 because of a high heart rate.
But to crystallize this case, which is, you would concede, I take it, the facts of the 07 incident are different than the 03.
I would concede, yes.
The JCC, I mean, the pacemaker, the recorded rate, that was the 03 incident was described as, was found to be vasovagal, right?
No, that is not correct.
Was it RVOT?
Dr. Mathias testified. Dr. Mathias's testimony was only taken one time, and that was before the final hearing in the 2003 date of accident. So his conclusion remained the same. His conclusion did not change at all. The vasovagal also, Dr. Mathias testified that that was heart disease. And he actually, if you read his testimony, kind of says, well, it might have been vasovagal, and that's a possibility. So, but I really think that if you focus on, it seems likely what the judge found, that, and that we're not contesting, he really found that the RVOT tachycardia was the cause of all three. That's not only consistent with the opinions of Dr. Mathias. I believe that Dr. Vidot's testimony...
Well, frankly, to me, it sounds like it's a seizure disorder. It doesn't sound cardiac at all. But since you are conceding that, and since you say we really can't say, we have a finding it's cardiac, we don't know exactly what it is, we therefore can't rule out job stress as a factor. How can you say that the presumption doesn't carry the day?
We can rule that out for two reasons. One is because the incident occurred before he was employed. The RVOT tachycardia...
But you could have stress before you're employed that was replicated or magnified while you were, thereafter when you became employed.
Yes, and that's correct. And the judge of compensation claims made a specific finding that there was no testimony presented that the stressors of work accelerated or aggravated the underlying condition.
Whose burden is it?
Well, additionally, there is also testimony that was asked of both physicians whether RVOT tachycardia could have been accelerated or aggravated by the stress of the employment, and both Vidot and Dr. Mathias said that they did not believe that it was. So we do have evidence, expert testimony evidence, that the stress of the employment did not accelerate or aggravate the underlying condition which preexisted the claimant's employment.
Okay, so you're saying the JCC found RVOT, and that could not have been job related.
That's
Therefore,
correct.
You rebutted.
That's correct, because the RVOT tachycardia existed, was triggered by, was caused by an incident that before he even began working at the state of Florida, and that there has been no progression in that condition whatsoever. Additionally, I just would like to stress the fact that this court has repeatedly stated that it's not going to reweigh the evidence of the judge of compensation claims. I'd also like to address that the points that were made that there was a negative cardiac workup. The evidence that the claimant's counsel points to really refers to the claimant's history that he provided. And again, that's kind of a red herring, that the fact that there was not a negative cardiac, whether there was or not, is irrelevant, because if you look at Dr. Mathias's testimony, he talks about how Dr. Naidu, even though he came to the conclusion that the claimant had RVOT tachycardia, he couldn't reproduce the symptoms in the lab. So therefore, it's a diagnosis that's difficult to pin down. And, an analogy would be, if you are diagnosed with, bronchitis, and later it turns out to be that your symptoms are lung cancer, the diagnosis doesn't begin on the day of the diagnosis. The diagnosis begins on the date of the symptoms. And so in this situation, it was kind of an aha moment for Dr. Mathias and Dr. Naidu, who was the one who did the testing and determined it was RVOT tachycardia, that, oh, this is the explanation for all of these episodes.
Is the appellant's attorney correct that there aren't any records from 95?
Yes, there aren't. And, you know, that's interesting. Certainly if there were records, I'm sure the claimant's attorney would have been happy to put them into evidence. But again, it's our position that those records would be irrelevant because, again, Dr. Naidu was not even able, at the time of his testing, to reproduce the symptoms that the claimant had. So when he did his actual diagnostic testing in the lab, he couldn't trigger the RVOT tachycardia. It was just something that came on the claimant. So his testing actually was negative. He had to make his conclusions based on what the pacemaker had recorded at the time of the 2007 episode, the syncopal episode. Another thing I wanted to point out that the judge relied on was that there were similarities between the three different episodes. He points out that at each time the claimant had, he became disoriented. He, kind of had some type of possible seizure activity. And Dr. Vidot also explains that perhaps the seizure activity is what's triggering the tachycardia. He bit his tongue, and that he had kind of amnesia after the event. He didn't recall what happened until he woke up in the hospital. And finally, I would like to address another thing that it was pointed to, that Dr. Payne's concern that the claimant's findings were all negative. Actually, what Dr. Payne said was that there was, he was actually concerned because one of the claimant had reported that all the findings, the workup was negative, but Dr. Payne had found that one of the test results that he had access to was actually positive. So he was concerned about that. So the claimant's ability to provide an accurate history is a bit questionable. Again, we would.
When were those results from that he said were positive?
There were, after the 1995 episode, there was a positive finding on I believe it was an electroencephalogram, and I believe that those findings were consistent both in 1995 and in 2003. That I think would more pertain to a seizure activity than to a cardiac issue, though. Again, we just reiterate that this court has made it very clear that it will not reweigh the evidence. The judge of compensation claims had ample evidence in the manner of opinion testimony of the claimant's IME physician and the factual testimony of the other physicians, as well as the expert opinion testimony of Dr. Vidot, to conclude that the 1995 episode, the 2003 episode, and the 2007 episode were all caused by RVOT tachycardia. Thank you.
Thank you, Mrs. Ortiz. Rebuttal.
Yes, when I say they had no records prior to, or in the 95, 96, I mean they didn't have the Crestview Hospital records. They did have Dr. Payne's office visit of August 95 and July 96. Now, the report that she states was positive back then, or the test, again, helps the claimant's position. It's on page 301 of the record. And it's July 29, 96, Dr. Payne's record. It talks about there was an EMG exam done August 28, 95 that apparently was a little bit abnormal, but the conclusion here is it was suggestive of central nervous system pathology. Nothing about cardiac condition. The burden.
Okay. The JCC says RVOT.
Right.
And counsel has just informed us that there is testimony that RVOT cannot be caused by occupational stress.
I believe the testimony was that neither doctor knows what causes RVOT.
Well, that's a big difference.
Well, okay, then I really don't know. I don't want to say whether they stated, because I don't remember that, one way or the other. Maybe I'm wrong. But I do know that both of them said they don't know what the cause of RVOT tachycardia is. Whether the question of whether does stress, can it aggravate it or whatever, I don't remember. If whatever question was asked or response there too, and I'm sorry.
I appreciate your candor.
Do you know which doctor would have addressed that?
Well, it's possibly both of them. I mean, there's two IMEs, Dr. Mathias and Dr. Vidot. Dr. Mathias had one deposition, Dr. Vidot had two. But the burden of proof of overcoming the presumption is on the employer carrier. They have to establish that the heart disease had a non-industrial cause. Now, it's RVOT tachycardia, so no one knows what the cause is, so they haven't established it that way. Dr. Mathias was asked in his deposition, page 98, if he had this condition prior to January 1997. His answer is, I don't know. So that doesn't establish that he had RVOT tachycardia prior to 97.
What's the best evidence they have to rebut the presumption, and why does it fail?
The best evidence they have is the portion of the record at page 450 that I read to you in the beginning. It does not rebut the presumption because the medical records that are in evidence show no evidence whatsoever that this man had RVOT tachycardia.
In other words, what the best evidence they have is an unsupported opinion.
Correct. Correct. I mean, for all we know, the man passed out in 95 because he was of overheat. Thank you.